So in the previous video, we talked about the general definitions and purpose of IP, or intellectual property. And what we're going to talk about here in this video, we're going to start with the benefits of intellectual property, what its purpose is for, why we have this idea that IP is a good thing to have, right? So IP, again, being intellectual property. So the benefits of intellectual property protection actually comes into play with the encouragement of new developments, new innovations, new inventions, new technologies. So it encourages inventing. And the way that this happens is by giving people access and rights to the work that they create for some period of time. Now, this can happen in a variety of ways. It can happen with copyright, it can happen with patents, and it can happen with things like trademarks. Now, we're not going to cover exactly what all of these things are. They are in the book, and there is that intellectual property crash course playlist that I linked in iLearn. I highly recommend that playlist if you're having a little bit of trouble with this terminology or would like some more examples, because it goes over a lot of information. It's a little bit too long for you to watch an entirely one sitting of this course, but it's a really, really good playlist on this particular topic. I think it's about 7 episodes, each of them being about 10 minutes each. Again, really good playlist there. But we're not going to talk about these in this particular lecture set. All right, but the benefits of IP, again, are that it encourages the invention and creation of new ideas and experiences. And what we want is for this to happen, right? We don't want people to not benefit from the work that they create. If you invent something, you expect to make a certain amount of money off of that, hopefully, and benefit from your labor in the form of monetary gain. Now, it doesn't just have to be things that have maybe intrinsic value, such as invention. It could be things such as a painting, a picture, a book of some sorts. You're going to still want to benefit from your labor of creating that particular item, right? So you want to benefit from the publication of your book. You want to benefit from the creation of that art piece you made. That is what intellectual property protections are for, is to protect people who create things. Now, when you're on the internet, anything that you type in like a comment box or anything like that could technically be classified as intellectual property and therefore subject to intellectual property protection. However, you often sign away your rights to these particular things when you sign up for these services. So it's important to understand where your particular rights stop and when another's begins. For example, when your rights to your comments stop and when the company can begin to take over on those particular rights. And that's going to vary from contract to contract, from end user agreement to end user agreement in this particular case. And we're not going to be able to cover all that because that's a lot of information and a lot of things to cover. Now, the cost of intellectual property, right? So the cost of protecting these things, particularly in the modern age, tends to come from things like DCMA, which we'll talk about in a little bit. But it comes from the fact that people benefit from IP, right? If it's an invention, right, then it could potentially make life a lot better. For example, whenever somebody invented the wheel, if that was something that was exclusive to a particular person who could sell that wheel and no one else could make it, that becomes a very difficult thing to handle, right? Like that could potentially have huge benefits to society, and obviously we see that it still has huge benefits to society today. So how do we balance the benefits to society to the benefits that we expect as intellectual property developers, as inventors or creators? So how do we balance societal benefit with the inventor's rights? And this is usually handled by putting term limits on copyright and other intellectual property protections. So, what exactly does that mean? Well, that means that when we have copyright on a particular piece of work, they only have copyright for a certain period of time. Now, initially, this was a relatively short period of time, and you would only be able to benefit from your exclusive use of that work for a short period of your life. Now, short is still relatively long. I mean, it was, I think, about 20 years. But more recently, particularly because of people such as, or not really people, but organizations such as Disney and other corporate holdings who have intellectual property that they want to protect, they have been trying to push for the extension of intellectual property rights in terms of how long it is for. So now it's something like the life of the author plus some number of years. So there's some discussion about whether or not that particular term and what is currently available and is fair. And I want to point out that anything that I'm saying about legality in this particular section is related specifically to the U.S. definition of intellectual property and intellectual property law. This is not necessarily international, and I can't cover international because one, we don't have the time in this course, and two, because intellectual property rights are very much defined by the country and region in which you live. So we are focused on U.S. intellectual property rights. Now, there are lots of different types of intellectual property. So like I said before, there's normal copyright, which is usually what we apply to things such as books, right? Music, any other creative piece of work that's more or less often fictional, right? So that's usually protected by something like copyright. But we also have things like trademarks, which is something like a company logo, and other, marks that a company might use. So there's another thing called service marks, which is very similar but a little bit different. We also have trade secrets. So trade secrets are usually things that are not necessarily protected by other formats of intellectual property protection, such as a copyright or a patent or something like that. But they are still protected in some way. Trade secrets are often things like KFC's, 11 herbs and spices, right? Is a trade secret what those herbs and spices are and exactly what, ratios they're getting used in. And there's something important to know about trade secrets is that even though the trade secret itself, the specific implementation might be protected, you can't protect against reverse engineering. So if somebody wants to figure out how your thing works, and they do, and then they produce something very similar as a result, that's not protected against, right? That is something that is technically legal in at least most cases. All right, the next thing that we can talk about here is a patent. So patents are very specific types of legal protection based off of applying for a patent. So you don't just automatically get a patent. In some cases, you do automatically get copyright protection. But for a patent, you have to specifically apply for it from the patent office in the US, and there's a whole process behind that. And then, of course, there's also some additional types of copyright that we're not going to cover. But all of these types of protections are talked about in that crash course playlist that I mentioned, and I highly recommend going there because I'm not going to get into any more detail than what I just said here. But these are the primary terms, the primary types of copyright that we will be talking about in this course and in this particular lecture series.